Welcome everybody to the Community Economic Development Committee meeting. And Matt, you going to do roll call?
Yes. Mr. Weddleton?
Here.
Ms. Kennedy? Here. Mr. Peterson?
Present.
Mr. Constant?
Here.
Mr. Dunbar?
Here.
Ms. Selatel?
Yes.
Chair, you have a quorum.
Thank you. So we got the agenda in front of us. Any changes?
Mr. Chair,
Yes.
just one thing we might add at the end of the conversation is conversation about topics we might discuss at this committee going forward.
Okay.
Mr. Chair,
Of course.
are we going to? We're going to take up the. Are we going to take up the violation
Yeah.
summary?
You want to add that?
So yeah, can I make a motion to add the? I think we should probably do it first, right, so that you can get back to work.
That would be great, thank you.
Yeah. So, yeah, I'm moved to take up the violation summary before item A on the agenda.
Second.
Any opposition? Okay, so we'll do the marijuana summary. A. Then I do want to talk briefly about the Studio 420.
Mr. Chair,
Yes?
could somebody email that summary to me when there's a minute?
Did that go out? Went out last night.
Mandy can.
I got it.
Mandy will.
There's a lot in there. And then, I guess B, we'll do the mining claims, and then near the end, did you have some specific items for future work, Chris?
Yeah, just I want to bring some items up.
Okay, so we'll make time right at the end. Will that work? Silence means yes. Okay. So we changed the agenda. We got 2 new items. Does that work? Okay. So, Rich?
It's our normal report. The top portion of the report is stuff that's been MOA generated, or we've changed it a little bit. I know we've said in the past that AMCO initiated an investigation or an NOD on a property. We're going to completely leave it to them. Changed seats a little bit on that. If it's strictly a metric or the excise taxes, we're still, since we don't have access to metric and the tax base, we're still going to leave those alone. But if there's an odor or an operations issue, we are going to open up our own investigation, kind of parallel them on that. So there's 2 on there. Actually, I think there's 3 on there. Alaska Cannabis Exchange, they've, if you look at the AMCO NOVs, they've had a number of odor violations. We confirmed one of them on the 21st, and they've been noticed that the next time, you know, there's probably going to be a citation involved in it. It is typical. What we run into, it's when they do the harvest and it just overwhelms the carbon filters. But passed on some information of one of the mechanical engineers who seems to really have the knack as far as getting those issues solved. We passed that information on to them. Hopefully they do, and hopefully we don't have to go back and see them again for another year. We just did their annual inspection for the facility, and everything was, you know, very good. Very happy with that, but it's just they just need to overcome that odor issue.
Is that Cannabis Exchange?
Yes. So we're behind SBS Minnesota, back there on 47.
All right. Next question.
Yeah, of course.
Are there complaints that are leading you to go out there?
Yes, from AMCO. When we went out there for AMCO, and we have had other complaints in the past. I think there's 5 throughout the year that AMCO had that we kind of took a backseat on, but we are going to be a little bit more proactive now with like I said, with the odor and the operation.
Is it coming? Are the complaints coming from the nearby houses or from the commercial the businesses in there?
The commercial business was the one, but it was, I can't say for sure. We were told anyways that the guy was trying to get out of his lease, so he was complaining about the odor issue, but that doesn't negate the fact that there is an odor issue out there that they have to overcome.
But have we gotten a number of complaints or any complaints?
We haven't. AMCO has. Whoever has been calling AMCO instead of us.
Oh, I see. So you're not sure if it's the houses or the business?
I'm not positive. I can't say one way or another for sure.
Thank you.
Any other questions on this? Chris, did you get this? Chris, are you there? He's busy with this. Going through the flow of this, it does worry me. You kind of worry with these things, which operations may be falling into chaos, and that worries me because maybe then they get loose with the rules. And Danish Gardens has always been a troublesome one. And here we've got inaccurate recording and metric, and that was pretty serious. They said every single room had an error. Delinquent tax kind of suggests a little turmoil. It's in there twice. I thought there was one, did they get their odor fixed up?
Yes, they did, actually.
That's
The
not-
mechanical engineer that I mentioned earlier went into their facility and fixed it. We haven't had a complaint or anything, and we certainly know one of the adjacent property owners would have let us know if there was an issue with the odor. There has not been.
So the year and a half of saying that the city was there to pick on him was a fact. His equipment wasn't working properly.
Yeah, I guess the mechanical engineer told Mr. Wyrick that he needed to apologize to us, but of course he hasn't yet, so.
I'm sure in his heart.
Yeah. We did his inspection, actually Monday, the annual licensing inspection for his retail and his cultivation, and there was no violation, but I just wonder I wonder if he can make it. To tell you the truth, it was kind of plants didn't look good, that sort of thing. So, but it's a subjective thing, but it's kind of what I observed. That I'm wondering if you're growing and drying in the same pot at the same time. So,
And that's what we see here, some chaos, and it happens to be him, but we need to think about what does it look like when a fairly big operation might fail? What happens to all their stuff? He's got nothing to lose. Things are going south. I don't know. We haven't dealt with that yet, but as the industry moves along.
true,
it
but
will.
we were on site, did the full license inspection for the retail and the cultivation, and there were no violations. So he says it's not pretty, but it's not in violation.
Any other thoughts? Okay.
Thank you. That actually raises a question, and this is somewhat my own ignorance, but when someone decides to close a marijuana facility, is there a final closeout inspection of some sort when they shutter their doors to make sure like that they've disposed of all of their inventory and everything else?
That disposal of the inventory would be monitored in metrics, so that would be the state that would monitor that. They, I don't know if you're familiar with metric, but in the one Danish Gardens is that they track it down to per room, which tags are in which room, so they keep a pretty tight rein on where the product is at. So if somebody was liquidating, they would still have that information in metric and monitor. We don't have any protocol in place ourselves for that.
Thanks.
Any other questions? Did we lose Chris? Do you know?
Yeah, I do.
Oh, you're there. Okay, Chris.
Thanks. So, Rich, do you have any of these, because I'm not there, I wish I were, but that you think we need to be watching really closely for the purposes of making sure we don't head south quick on any of them?
Yes, we still have issues with Alaska Scent, and we just did their annual inspection, and we will be coming back to you. There's quite a log of inspections that we've done there, but we'd like to give Mr. Dole the benefit. He needs to be in the loop with what our recommendation is going to be as far as the licensing approval. So he gets back Friday, so we'll be talking about that then. But there are still issues with Alaska Scent.
Cultivation or retail?
Cultivation. Retail is fine. It's the cultivation that's in its odor again. It continues to be odor. What's happened there is they did a lot of different things. They had some personnel changes. Things definitely have gotten better over there. And I know AMCO's been happy with those changes, the personnel changes there. They still have an odor issue. They did hire the said mechanical engineer, did the work. They've got the bid from Diamond Heating to come in and do the ventilation work. They just haven't done it yet. There's also an issue with their building permit. They've been extended 3 times for their CCO, and Mr. Dole has done a letter to them saying that you have, I think, August 21st, their CCO expires, and Mr. Dole is not inclined to extend that CCO again because the issue is there's a site plan that was approved part of the special land use permit, but it's also a portion of the building permit. And we've been reminding them and their council repeatedly that you need to at least get in here and start the modification process, and they haven't done that. So Alaska Census will be back before you. So it's just, I want to give Mr. Dole the benefit of, since he's our boss.
I appreciate that. Chris, anything else?
No, I think that covers it. If there aren't any others we need to be watching, that's the one we'll be watching.
Yeah, we had AK Joint, which is the old not SBS, Alaska Industrial Hardware building down on Post Road. They've had odor issues off and on. Well, we've had a lot of complaints. We really haven't verified the odor issues, but we had kind of a serial complainant, if you will. And what we did there is, actually it was me, because I dropped my wife off at City Hall in the morning, and it's convenient for me to go by there. So for about a 2-week period, I went by there every day virtually, and never, and that was the time that the complainant was saying the odor was bad. It was early in the morning like that, and I never got any odor the entire time. So I don't know if it's just I don't know if there's a personal issue involved or something, and I'm not saying that they did have a couple of odor issues, and I think they've overcame that. So,
I think that forest fire is probably helping on that.
Yeah.
yeah.
One last question. I think that you might have covered this, but it was a little muffly. The inaccurate metric recording for Danish Garden, that the amount of plants doesn't match for all their rooms, and we inspected that one, it looks like. And what's the plan there?
My understanding is it wasn't the weight that was anything was wrong. It's just they had the plants were listed as being in one room, and they were in fact in another room.
Okay, so we're not looking at a diversion thing or some kind of weird weights and measures. It's literally just geography.
Yeah, housekeeping of where your plants are at and what room they're in and where they're supposed to be. That was my understanding of that one.
Thank you.
All right, thanks, Forrest.
Yeah, I'll just note that. I mean, it's just an example of the remarkable amount of regulation this industry is I don't want to use a pejorative term, but that they experience. But I wanted to ask, just thinking about the serial complainant where we were unverified, and this is my own ignorance, but I know for police calls, we have an ordinance that says if you make a number of calls that are unsubstantiated, or whatever the proper term is, eventually you get a fine. Do we have anything like that for, not just for marijuana, but for code enforcement in general?
No, we look at it as kind of like the Coast Guard. You got to go out regardless, so we will go out and take a look. Of course, we learn over time with certain people that there may be personality issues. We have neighborhood disputes, which is something that happens quite a bit. And lo and behold, there's some mental illness in Anchorage, so we have a couple of those callers that will call us for anything.
Okay. Well, I mean, it's something, I guess, Chris, Mr. Schutte probably has the best sort of 30,000-foot view on this, but if it comes time to think about such an ordinance, if other cities do that, I mean, that's something that would be worth entertaining. I mean, you'd want to have exceptions for mental illness and that kind of thing, but if people are abusing the process to harass a neighbor using the code enforcement process, then I think they should be subject to a fine.
Excuse me, through the chair, I think that's certainly worth discussing. We don't want to obviously discourage, but absolutely, if it, in the same way that excessive APD or AFD calls through 880s can be fined as well, then I think that this is probably something worth discussing. I also think that another topic worth discussing later is the point that I think you raised, which is we don't really do a good job of envisioning what end of life is like for a marijuana licensee, other than if they die. That's really the only code provision, how to deal with something if they die. So we can easily infer what a wind down looks like, but there's nothing explicit in code that describes what we should expect as a community. So that's also something I think we should consider at some point.
Thanks.
One last comment for that, you know, with this facility at the old AIH building where, Rich, you're not able to go by when there's aromas coming out. About a year and a half ago, it's been that long since I spent any time down there really, but I was there when it smelled really strong. It was as if they didn't have any management for odor. And I heard a lot of complaints, but it's good to keep an eye on that.
Absolutely. We do drive-bys, and you know, each officer has, you know, assigned geographic area of the cities, how we're broken down, and of course within those areas, they're aware of where the cultivation facilities are, and it's common practice that they'll just do, say, a drive-by 3 or 4 or 5 cultivation facilities in any given day, and I do the same thing myself. So the vast majority of the cultivators are doing a very good job keeping their odor under control, and it can be done. That's what's a little bit frustrating sometimes is they say, well, I can't do it. It's like, yeah, you can. It's just, it costs money. And in this case, I've been told that the work that Alaska or Canavasca, I use the two one and the same, it's about a $40,000 improvement to the ventilation system that they're looking at right now. So it's not cheap, but it's doable.
All right, thanks. Anything else for us? Chris?
All good.
Pete?
Thanks, Mr. Chairman. So, I think, we're talking about what we might expect when a business is winding down their activities. I think what may happen is they will get bought out by another more successful business, and there's already some of that consolidation going on. I think the market is there for the production that we have right now. So I think if one person just can't get together enough to get all the bills paid, someone else will come in and grab that facility and make some improvements.
Pete, if I might, Mr. Chair, on that note, like one of the tax behind people that's on this list, their facility is in the process of being transferred to a different operator.
Good to go.
All right, is that it for this topic? Next. Okay, next is Studio 420. Thanks, Rich. Is anyone here for Studio 420? Okay, come on. Okay, can you introduce, we should probably go around the table actually, I forgot to do that too for other people. So we have Dean Gates,
Chris Schutte, Director of Economic Community Development.
and then go ahead and you're,
Abe Bullock.
Tammy Benoit.
Ryan Yell, Planning Department.
Mandy Honest, Clerk's Office.
Michelle McNulty, planning.
Dave Whitfield, Planning.
Emma Torkelson, staff for Dyson. Matthew Wilson, legal assistant.
sorry, we get Julian.
Brendan Raymond Jacobian, I'm just an audience member.
Julie Raymond. I'm Becky Whitfield, municipal attorney.
All right, thanks. And we should probably, thinking of the recording, say who we are before we speak. So when you speak, mention your name again, just so it gets on the recording. So we're going to go through our regular routine here. Okay, so have you come before? So what would, these meetings typically it's a chance for assembly members to talk to staff about these because of open meetings rules. You can only do it in a public meeting. Okay. So you'll have a chance to speak too. But if you want to speak, just raise your hand. Okay. Don't just jump in. And you'll definitely get called on. We want to hear what you have to say and talk about this. So we've got a little routine. So first would be Mandy.
So Studio 420 AK, this is for a retail license. So recently the clerk's office received notice from the AMCO office that the Marijuana Control Board denied the state license. So this would be a potential amendment to maybe add a condition. So this changes that all licensing restrictions have been addressed. One of the requirements for a muni license is a state-approved marijuana license. So that would be a recommendation to potentially add as a condition. It is a requirement anyways, but just as something to outline, we could do an amendment and add that as a condition that resolution with the state of Alaska for the state license must be met before the municipal license will be issued. Other than that, no taxes, fees, or fines were found due. All of the safety and security standards were addressed in their operating plan. All of the retail facility specific requirements were also addressed in their operating plan. There wasn't a mention of concentrates, but if there is, they need to be stored securely and temperature controlled. And so that was the one recommended potential condition.
All right, thanks. Ryan?
Thank you, Mr. Chair. Special land use permit for a marijuana retail sales establishment within a D3 district. Site is located southwest of the intersection of Spinard Road and Wisconsin Avenue. That proposed establishment is located within an existing commercial strip mall. Approximately 1,400 square feet of available building space will be dedicated to marijuana retail. And the hours of operation are 7 days a week, 10 a.m. to 8 p.m. The closest protected land use is a child care facility located approximately 950 feet away from the petition site, and that's measured via straight line. And this use is consistent with the Anchorage 2040 land use plan, and the provided site plans do not show any major alterations to the building facade or structure that make it a dissimilar character, scale, or size when compared to surrounding structures. We are recommending approval in the staff report. However, the property owner's authorization is still pending. We have not received that yet. So planning department is recommending further postponement in this case.
Okay, thank you. Okay, so your report said that, but then it came, so you haven't made a change, and we were waiting, and is there any progress on that?
You guys made any progress on that?
They're still, the lawyers are still hashing it out, basically.
Okay, so that's Abe speaking. So,
I'm
can you
sorry.
give us a rundown? So, the issue was, someone owns the ground and someone owns the building. You had an agreement with the building owner, and we need approval from the building owner and the landowner.
Abe's, well, correct. Yeah, basically, they're in conflict with, I guess, the lease agreement they have. The lease agreement they have basically states that the landowner has to sign any paperwork that in regards to the leasing of the mall. He's just being difficult, and so we have to get the lawyers involved, and that's kind of what we're waiting for.
And you know that stops things, right?
Yeah.
So, on Tuesday, we can add, definitely want to add that condition that they need to just highlight that condition. And then would you write something also then that says, would it be pending waiting for that agreement, or do we just park it?
I don't know if any action can be taken by the assembly at this point. I think the postponement is the best option.
Mr. Chair,
Chris?
I think that we should, whatever vehicle we have, is put it, park it, postpone it, wait until the state resolves their question before we even pick it up.
Any thoughts, Forrest?
Yeah, I was thinking when Mandy was describing adding another provision that we could, in theory, pass it and just say this is a conditional on you eventually resolving the issue with the state. But I do think the postponement is probably a better option. Do you have any sense for the applicants? Do you have any sense of when this will be resolved? Because if we postpone it indefinitely, it's usually equivalent to killing it. I would rather postpone it to a date certain. So we'll postpone it to sometime in August, and we'll take it up.
We were supposed to, Ames Papul speaking, we were supposed to hear something this week. We haven't yet. I know the building owner is on vacation, so they're kind of waiting for him to get back as well to continue the conversation. So it looks like I would want to say at least it's going to be at least 2 weeks before we hear anything.
Well, that timing works out pretty well for us.
Yeah.
So perhaps we just postpone it until the first meeting in August.
So you're just saying just kick, so when that comes up, just move the public hearing and everything?
Mr. Chair.
Let's do the public hearing in my direction is to do the public hearing because we've already announced we're gonna do it at that time. We've talked about this a bunch of times, you don't like doing this. So we have the public hearing, closed public hearing, we postpone debate until the first meeting in August, and then we see if they've resolved it or not.
What does this do? I'm sorry, Chris, go ahead.
Thank you. So I'm hearing conversation about a landlord issue. Isn't this the same one that AMCO sent us a letter that said they didn't even have someone to move the license and based on a number of factors?
Yeah, let's finish this ownership thing, then we'll delve into that. Does that work?
Well, except that whole conversation impacts the decision we might make toward postponing to what time or, you know, et cetera. So we can take it up after, but I would suggest that if we do that, let's not make any kind of recommendation on how we take it up at the meeting until we've heard the whole suite of issues.
Okay, yeah, we just have one more comment on this. So, Dean?
Thanks, Mr. Chair. Related to this timing, I think it would be helpful to know if AMCO's, the director's delegated authority for the state to approve this license when it comes back before them. I know the board denied the license, but then they might have to go back to the board, or can they just go to the director? Because then we have to look at the timing of the Marijuana Control Board's meeting and if they're going to make the decision to them. And if they delegated authority to the director, then that postponement to August may make sense. I don't know when the Marijuana Control Board's next meeting is. And that might be able to consider this application brought back with owners.
If I could add something in, Abe's Bull speaking.
Hold on just a sec. Let me. Okay. Anything else on that?
Well, on Dean's point?
Yeah.
Yes. I mean, reading the letter, it indicates this kicks up into an administrative appeals process. It could be a very long time before anything's resolved on. I mean, in there, that could just end up with a remand back to the board. I mean, I feel like that's a process that kind of needs to play itself out before. It doesn't make sense to me to put some major condition on the license that you have to go back to the state where it seems to be that's actually a condition precedent that you need to satisfy before really getting to the municipal one.
Part of the state's administrative appeal process, as I understand it, is they can request an informal meeting with the director first. It might get resolved quickly, but then Southtown's right, it could take a long time if it goes longer.
And I don't, Abe's Bull speaking, that's not the route where we will be taking. We'll be requesting a formal appeal. So.
Okay, so we got a letter. It just said no one moved to approve it. And were there reasons given? I didn't see them.
Yes, there was.
Can you outline those?
Yeah, based on my last business that I operated here in Anchorage, Alaska, I was the owner-operator of Lucky Times Pool Tabs and Lotto. I successfully completed 3 lotteries, which I gave away $500,000, $350,000, $250,000. At the same time, I also owned a pool tab store in conjunction with that. We operated out of the same building that we are applying now to go back and operate a marijuana retail store out of. Basically what happened is I came into owning my permittee. It was approximately 2.5 to 3/4 of income or their net proceeds. So basically the marijuana, or not the Marijuana Control Board, but the Gaming Control Board, which I used to work for, basically came in and stripped away my license, my permittee's license, and basically said, hey, you owe your permittee $30,000. Until this is satisfied, you're basically closed down. Me and my wife at that time, because of all the pressure of lawmakers and governors and legislators, decided not to continue the business anymore. I successfully have completed, all the terms of the judgment because there was a trial involved. I was found guilty of misapplying property because I was paying my bills before I paid my permittee just to keep the store open. Basically, I paid him. I did 6 months of ankle monitoring and 3 years of probation. Successfully completed it. I successfully paid off all my restitution to the state and the city, which was $35,000. And it's been almost 8 years later. I've been in the marijuana field. That's how me and my business partner met. I started off the bottom as a janitor and worked my way up to retail and cultivation, trying to get learn the business from the bottom up. I met Tammy Benoit. She also was doing the same kind of jobs that I was doing, and we said, hey, one day we'll open our own retail store and do something for ourselves, and that was the plan. The Marijuana Control Board, we had missed the first meeting on May 3rd. We got called back in person this time, July 11th, to be heard in front of the board. We got there and we're basically showing no respect, giving no reason, dismissed, nexted without any reasons why, anything. We found out later in a memorandum that Erica had sent to the control board that she inaccurately put in there that I owed the state of Alaska and the municipality of Anchorage $119,000. Since then, I have proven documentation from the courts and from everyone, and I supplied them to AMCO that basically that's not the case. That I paid my restitution in full to both the city and the state, and that's where we're at.
Okay, thank you. Okay.
Thank you. I think we should just hold off because that sounds like a really complicated procedural history, and looking as well at what AMCO kind of cited for the reason of the 080 regulation, it doesn't suggest that you can just not take action. So I think this is really a sticky situation. We should just kind of hang back.
Mr. Chair.
Has this been, this has already been introduced though, right? I mean, so we can't.
Postpone indefinitely.
Right, so I don't know.
Through the chair, your options at this point are to postpone indefinitely or to deny the license.
We can postpone to another date.
You also could postpone to a later date certain, but I think the discussion you're hearing about since we don't control the state licensing or appeals process, we don't know when that is, to be fair.
Crystal?
Well, to postpone indefinitely isn't really just to kill it. I mean, we can always bring it back. If it's 5 years later, you bring it back. But
Dean?
I guess another option is to do both. You could postpone for 2 months, see if it's resolved, and then postpone indefinitely if it's not. Take it up if it's resolved.
Just for Mandy, I'm sorry, Chris. You want to do?
Yeah, thank you. I just want to concur with folks who are stating that the best process will be to postpone it and not take action because the AMCO board didn't even move this license, right? Nobody was willing to move it based on the facts that they have. And so we really need to wait until they've sorted through their facts before we take this on. And so yes, we can get there a number of different ways, but that's the tactic we have to go. And I think I would defer to legal counsel's opinion on this, but we definitely need to wait until the state's sorted out their business.
So you're suggesting potentially postponing it for a month or something to bring it back up?
I don't think they're going to resolve this in a month. I don't think they're going to resolve it in a couple months because of all of the legal ramifications of all the questions. No one even moved the license. No one was willing to put their name down to say, I move the approval of this license.
Okay. So, man, if this were postponed indefinitely in the meeting, what process do they have to go through to try again?
If it's postponed indefinitely, it's on pause. And so everything that they have just kind of sits until the assembly brings it back before them. And so it would come back to you as is. And then if anything was worked out in the meantime, we would add it as an AIM or potentially an S version if it was substantial.
And the S version could be, and they would come back, let's say, at AMCO approval, so they got the
Right.
AMCO state license, and then landowner approval. Otherwise, it wouldn't make sense to come back at all.
Right.
And that S version could change Ryan's review, this has been solved, and your issue. So, but they don't have to do the whole filing fee and go through the whole process again. Thanks. Boris?
Can I ask Dean, you might be the most appropriate person to ask this, how actually, in the years I've been on the assembly, I've never seen an item that's postponed indefinitely brought back. How do we actually do that? Because you need some motion from an assembly member, correct? So if you do that, is it at the same meeting, or you bring it back for the next meeting? It's already introduced. How do you bring it back?
Mr. Dunbar, I have never seen that either. I mean, it doesn't mean it didn't happen. Maybe I just didn't see it, but I'm not sure exactly the process. But one way or the other, you can bring it back.
Well,
and I will have to look into that.
I think it has interesting.
I think I would add one other thing, if I may. If you postpone indefinitely, of course, some of the action, like Mr. Kennedy said, could bring it back in 5 years, but we have a special land use permit application as well, and then Title 21 application expires if it's not, I guess, put into operation or passed within certain times. Is that right, Mr. Young?
Through the chair, that's correct. So it's 1 year, so they do have a full year of inactivity while that special land use permit. But granted, the special land use permit was never approved, so it can't necessarily expire. But for the purposes of Title 21, to reintroduce something, it would just have to be properly noticed 21 days prior.
Mr. Chair, I think that we have extensive flexibility in how we address this question if it comes up before us again.
Okay, so your point is if we postpone it indefinitely, we have time to figure out how to bring it back? Is that what you're saying?
Yes, we can always figure that path out. It might require some new form of application materials. It might require us reviving something old. It might require updated forms. We can get there, but what we really need is the state to make their determination.
All right, thanks. Pete?
Thank you, Mr. Chairman. And so we could postpone it to the last meeting in September, and if nothing is progressed at that point, we could postpone it again until the last meeting in November or whatever. And that would at least keep it alive, and which would give you guys an opportunity to have the lawyers do their thing,
Okay.
We did talk about what if we just denied. So what's the effect of that? So we haven't really talked about what the effect of that is, because that's our other option.
If the assembly would deny the license, it would put them back at square one. They would have to submit their muni stuff all over, and it would still rely on a deemed complete and issued state license before the muni license would be issued.
Okay. Is there a required lag, like you can't reapply until?
No.
Okay.
Not for the license.
Mr. Chair, for the special land use permit, it's 1 year.
Okay.
Once they get it, if it's not used, then it lapses.
If it's denied. So they
Can't
have to
reapply.
wait 1 year.
Okay.
Reapply.
Okay, thank you.
Boris?
Yeah, I mean, I don't think Ms. Zalatow is suggesting we make that kind of recommendation out of this committee. I would just say that based on the state not taking action, to me isn't strong enough evidence for a denial. I would say to Mr. Peterson's suggestion, I think, and Dean, if you could research this before Tuesday, what actually is the process for bringing something back? Because what I don't want is, let's say they somehow do resolve it in August, and now it's not back up before us until the end of September, and now they've lost the potentially, weeks or even a month of operation. So I do want to maintain maximum flexibility so that once it happens, we can be on the ball. So if it is relatively easy to bring something back, then I actually think that postponing indefinitely might be superior. But I have to know before Tuesday, before we make that motion, what that actually looks like. Because if it takes a month to bring something back, or whatever the time frame is, that doesn't really make sense.
But don't we need to do something with the 21 days? So, I mean, we're already looking at zoning just said they need 21 days notice. If we postpone indefinitely, then they have to give another 21 days notice.
You have to advertise.
They have to advertise, they have to renotice it for 21 days.
No, why? Because we're doing the public hearing on Tuesday. Why would
This
we
is
have
related
to
to
do
this
this?
one, not your public hearing.
Oh, so because it's passing.
So
the
that
mailing and everything?
I'm sorry. what was that?
Mailing and everything?
Well, if you're gonna hold the public hearing, close the public hearing.
Yeah.
And then not take action until date uncertain, then you wouldn't have to advertise. But if you're going to postpone indefinitely, not hold the public hearing, then you need 21 days notice.
No, I think we should do the public hearing.
Next thinking, Chris?
Yeah, I understand the desire to streamline the time and make sure it's as least burdensome as possible on the applicant. I don't think I've ever argued to make things more burdensome, but from the perspective of protecting our process and the credibility in the public and everything else, we should postpone this until such a time as we have some sense of what the state's going to do, which means indefinitely.
I think we're arguing for the same thing, but for me, having the public hearing on Tuesday actually is better for the public because they know that it's happening.
I don't believe we have the right to not have the public hearing because it's properly noticed and it's on the agenda. And so I don't think that's the question. The question is what to do next.
Okay. Meg?
One last option I want to ask about, could we continue the public hearing or not? Because you have to continue it to date certain. The reason I ask is we could potentially get testimony about the fact that AMCO has denied the application and not get potential substantive testimony about it and get stuck in the procedural loop. So
I would say that if you're going to continue the public hearing and the next meeting doesn't happen for a period beyond 30 days, you have to re-notice.
Okay, great, thank you.
And I might offer in my conversations with folks at AMCO, the message I'm getting back is the current board is very unlikely to make a change in their determination based on the membership that they have. If there's some legal argument made by the applicant that goes to a hearing officer or the superior court that demands and has found that the AMCO must proceed, then they might change. But at this time, we're doing all this work based on a hope that AMCO might change their mind that is, in my understanding, pretty unlikely.
H. McCool speaking. That's why we're going to the formal conference hearing instead of the informal. We believe that we wouldn't get a fair shot with AMCO having the final decision on what's going on.
Again, which argues for this could take quite a long time.
Okay, so summing up, if I got it right, on Tuesday we can deny, we can postpone to a certain date, we can postpone indefinitely, or we could approve with the conditions that highlighting that they need the AMCO license, or state license, and also the landowner's approval.
Mr. Chair, I don't think option 4 is an option, given that we don't have authorization from the landowner. So
But it could
as
be
of
a
now,
condition,
it's
though. So it'd be with conditions, which would be landowner approval. But you're saying we can't even go that far?
Chair, you can't approve a license that requires as a prerequisite property owner approval. Right.
So if we don't have that on Tuesday, then where are we? That's a different discussion. If they don't have landowner approval, we just deny them.
it would still be postponed, is what we would request.
Okay, so 4 doesn't
they
work.
can still address this.
So we have deny, postpone to a certain date, with or without continuing public hearing, or postpone indefinitely. All right. Okay, so are we going to make a recommendation, or are we going to wait till Tuesday? Someone can make a motion.
I would move that we postpone, we recommend that the body postpone indefinitely.
Got a second on that?
I'd move to amend that slightly in that we move to postpone indefinitely by holding public hearing so that we don't run into the notice issues.
We will have a public hearing one way or the other because it's properly noticed on the agenda.
No, so we'll definitely have a public hearing. I
Okay,
think
so
that's
that
a given,
happens no
right?
matter what.
Right, I think,
Okay.
is that correct? Okay,
I
so,
mean, you could make a motion before opening the public hearing, but we should.
no, I think we should have a public hearing.
We should open it.
I think that's.
That's my.
Okay, so we'll have
novice.
public hearing, and then typically then we'll say, okay, close the public hearing, and we say, we reviewed it and we recommend X.
Okay, I will withdraw my amendment.
Okay. So we have a motion to, that after the public hearing, to recommend postponing indefinitely. Is that correct? Any opposition?
Yes.
Is that yes opposition, or yes you agree?
Yes, I agree. You framed it properly.
Okay.
Mr. Chair, I'll just add also that during this discussion, I formulated a formal question about the option for postponement and what it's like or what the process is for bringing it back in response to your inquiry for the clerk. But I've copied several of you on that so we all can hear it.
Okay, do you want to, we'll read the email, or you want to talk about it now to move on?
I just took his question and put it in an email
I see.
form.
Oh, I see. I thought you had an answer. Okay.
No, not yet.
Okay.
She's not that fast.
So, Abe's proposed before you guys adjourn. So, what exactly does that mean for us? Like, if you guys, if it's indefinite, postpone it indefinitely. How do we bring that back in front of you guys? Let's say in a month we hear back from the court, district judge, and we also hear back from the landowner. What's our next process in moving forward?
I should clarify, at the hearing, I hope you'll be there. The public hearing will open, and you certainly have the right to speak, as anyone else would be there. You have 3 minutes, so that's 3 minutes each. You can actually cover a lot of ground. But then it goes, we'll close the public hearing, and then it goes to the full body to make a decision. So we will simply say, this committee recommended X, but we're only 5 of 11.
Okay.
So it's uncertain. I can't say this is how it will play out. But I think on your question, that's what, Chris, we will have more information on Tuesday.
As far as your options, Mr. Chair, yes, you'll have options. To answer your question more directly, if this goes forward and it's sitting out there in postponement land, you'll have to work through the clerk and through Ryan, much like you did for the application, to get all the required boxes checked. And at that point, Mandy will be able to notice the assembly that the items have been met. Whatever the process is for you to reconsider the item, you would follow that.
So then we bring it back. But that saves you having, if we deny it, you're at 0.
Yeah.
You start all over again.
Yeah.
And then Clark has to wait a year because it's left. So
Right.
this buys you a little bit of time.
Okay.
So we are not approving the license, but
Oh, yeah.
And if I might, Mr. Chair, once AMCO forwards over a recommendation, then we will pick it up. It's not that hard.
Okay.
yeah, good. Thank you.
Thank you.
Anything else on this? All right. Thanks.
Thank you.
Thank you.
So next is federal mining claims and municipal land use regulations. And this, catalyst of this is something that we introduced in, do we have a public hearing?
Yeah, public you hearing did.
But we
last week.
postponed it because we didn't have answers.
Correct.
See what happens with the notification.
I know, and I was a working vacation too, so.
Okay, so we didn't have the information we needed, and we did have, Brendan and Julie have been active from Girdwood, and I think, are these seats available?
Sure.
So you could sit at the table.
No, you're good. You're good.
If you guys want to sit up, just.
Mr. Chairman, we're under a little bit of a time crunch for our attorney. That clock is actually wrong, and she needs to leave in about 5 minutes. So if we can have her go first.
Yeah, absolutely.
Yeah, I apologize, sir. We have a last-minute meeting at EPD about the situation on the park strip, so I need to adjourn and go talk to them. But I wanted to apologize for having incomplete answers for you guys last week. I was relying on my friends here from Fuji County Development Planning being there, and then when they were not there, I was, as was clear, caught off guard. I just wanted to make a few quick legal comments to frame the discussion before these guys get into the details about what the proposal is and why, and answer your other questions. There were some questions about whether or not, what's the legal ramification of not doing this, and I wanted to make that clear. There is a ramification for the municipality in terms of takings claims if this isn't incorporated into this zone, because these are pre-existing federal mining claims, which will be completely devalued if we don't allow them to go forward. They're not. It's not like this is just usually regulatory takings claims are a little shakier ground because it's like, oh, I can still do this with my property, but not this, which might be more valuable. This is pretty clear cut because these are just mining claims, which would have 0 value if we were to not allow them to make use of them in this zone. So it doesn't mean you have to decide a certain way, but that just should frame the discussion of what will happen if these aren't incorporated into the zone. In terms of whether or not we can legally require some sort of conditional use permitting process, yes, we certainly can. Federal mining law basically says we can't be less stringent than federal mining law, we can be more stringent. So we can add more requirements before someone is able to do resource extraction, but we can't be less, essentially try to waive federal requirements. I know Michelle and Chris will talk to you about why resource extraction wasn't simply incorporated into the use table as a conditional use. There's good reason for that, and they'll explain that to you. But if you wanted to create a conditional use mechanism, you legally certainly could. I think that's all I have to say legally. These guys can give you all the rest of the background. Again, I'm really sorry to take off. I did not think I would have this meeting this morning, and then I've been getting text messages from the chief of police, so I need to go talk to him. But is there any questions for me about the legalities of this before I have to leave?
They know the answer. If we added not as a P but a C.
Yeah, they know the answer why that's
We'll talk
it's
about
more
that.
complicated than that. I guess the other thing I wanted to add, because this is a question I had, was why don't these qualify as pre-existing non-conforming uses? And the reason is that they're not all in use right now. So they are pre-existing rights, but not all of them. I think actually most of them have not even been used. So this came up because the state said, hey, we want to make use of our permit to get some gravel out here next to the highway. And planning said, oh gosh, that is a new wrinkle we haven't dealt with. So they wouldn't, while they're pre-existing rights, they don't meet the standard and code because they're not in the continuous process of resource extraction that would allow them to claim those rights. We also did discover that this has never been in the code for this district, so it wasn't simply like an oversight when new Title 21 was operated. It was just something that was not acknowledged that these rights existed in the zone, and thus this question of whether or not this would be a regulatory taking hadn't come up previously, so it's a new question. Anything else I can help with?
We do have other parts of the municipality where there are gravel extraction operations going on. So can we use those same criteria for those operations to put on that, or would we have to totally do a different?
Not necessarily, through the chair. That we can't. Is there a little going to be apples and oranges discussions if we're talking about other existing gravel operations?
Mm-hmm.
So I'd like to separate those.
Okay.
Really, this is an ordinance specific to these material sites in the Girdwood area, but along Seward Highway and used by DOT. And it's very specific purpose and use, and it's a little bit different than many of the gravel extraction you have in your area, for example.
Yes, for regulatory taking, what kind of exposure is that for the municipality if we choose to not do this and it amounts to potentially a regulatory taking of the mining claims?
Well, and anyone who holds the mining claim could then sue the municipality for the value of the claim that we've taken away. So it would be, and I don't know how much these claims are worth.
Okay.
But they would presumably, again, not the case that they were now denied the use, whatever, how many cubic feet of gravel they're allowed to otherwise extract.
Okay. Okay. Thank you.
So, is it? I'm sorry.
No, go ahead, Cory.
Is it all gravel? Is that the only kind of claim we're talking about?
No.
These five?
No, they might be various.
No, I know, but like these specific to get one of these. Forgive my ignorance on federal mining law, but to get one of these sort of patents or whatever the term is, you have to prove that there's extractable resources, right?
That's a good question. Honestly, I don't know the answer. I assume that you have to at least know, believe there's something there for you to extract, but I honestly don't know how. And I'm also not tremendously well versed in federal mining law.
And so we don't have a sense. Do we have a sense that of these five, some of them are gold, some of them are copper, some of them are gravel, or we just don't know?
These five are all gravel.
These five are all gravel.
These five are all gravel.
Yeah.
But there
And
may
through-
be other claims that are gold.
Right, through the chair, what you're talking about, if you're talking gold, could be something like a placer mining operation, which is entirely distinct from this.
Yes, I was wondering, from what you said, they're not actually operating using those rights, but they have the rights. And the AEM attached here talks about federal mining claims to continue operation and allowing operations to continue under these existing patents. So that's a little mistake in the language, isn't it?
Yeah, I think that the AM isn't. The AM also says it was an oversight to not have it in the new code, right? And I think that that's sort of also the clarity is it was an oversight to not know that these claims were in this zone,
Yeah.
but not that it was. I had originally read that, but not to interpret that as it was in old 21, but not in new 21. It's never been in this zone. But I agree with you also, Dean, that was also, and this was part of the reason why I think I gave such terrible answers. John, you should know that Chris sent me a photo of your face when I gave an answer to one of the questions, and it was suitably doubtful.
Camera was perfect with hands up, right when you got that answer. You not happy.
Poor answers. But that's correct, that they are not, that was a point of clarity I also wanted, they're not currently in operation, and that's why they don't, again, meet the pre-existing non-conforming use requirement. They are existing rights, but they have not, no one is actually out there extracting anything from the ground right now.
And I'll add one other distinction. I didn't get copies of the patents for all of the sites in question, just the one that kickstarted this discussion. And the original BLM language, the transfer to the state of Alaska, is very specific in that it's a material site, not a valuable commodity extraction site.
It's even as specific to say how much material. I
Correct.
think that one it's capped at like 67,000 cubic yards, and we would assume that each of them are capped at a certain amount, and they would be held to that.
These are owned by DOT?
They were
DNR.
transferred to DNR. And
Oh,
then-
DNR. Oh, the state owns these?
Yes.
They're not privately owned, any of them?
No, these
No,
are
not
all
the-
DNR.
not the ones we're talking about.
Somehow I missed that.
So these are none of these were okay. So this is clarification. These are only state and federal patents, so they're on state or federal lands. They're not on any private lands.
Correct.
So
Yeah, I'm gonna back
thank
up
you
to
so
this.
much.
I'm so sorry.
So they're the ones who got the service.
Correct.
State.
Yeah, and if there is any federal, we are not 100% certain that there aren't any federal patents, but they would also have room to service as well if they had one in one of these districts that prohibited it. So if I can, and I want to first apologize also for that planning wasn't there to answer the questions. So we'll definitely make sure we're there next Tuesday. But if I can, I'd like to kind of walk through how we got to where we are, so that you could to also kind of help with the rest of the context of why we ended up with adding this language versus just putting in the C in the use table. So about earlier in the year, Granite had called and asked for a pre-application meeting for a conditional use permit for gravel extraction site for a road project they were doing. And we got the site and we said, oh, sorry, it's a prohibited use. You're not going to be able to come in, so we shouldn't have a pre-app. And they had said, well, we have a patent. We really want to come and talk about this. So when they came in, they clearly had a patent showing that they had rights to this, not only that specific site, but 4 others in the area. And all of them within areas where within Title 21 it was prohibited. So we evaluated, okay, could we consider these non-conforming? We looked at every site, and non-conforming rights, you lose them if they haven't been active within a year. There's a lot of other kind of caveats, but one of them is, has it been actively mined? So they clearly weren't fitting in the definitions of being a non-conforming use, so we had to evaluate, okay, how do we make this allowed, but also be sensitive to the reason why it was prohibited, that the community didn't want to see mining in these areas. And so we went through code, and so under the GIP, which is the Parks District and Institutional and Parks District in Girdwood, they have this language about federal and state patents. And that was cleaner to add that, because if we put in the C in the use table, that means the whole entire district gets opened up for anybody to come in, and in any area to come in, to apply for a conditional use permit. By just including this language, we were able to limit that to the specific areas where there are existing mines. And we also got clarification that they're not conveying any more of these. So we knew that we weren't kind of opening Pandora's box. It would have to be something that existed. It couldn't even be something that was conveyed after this is adopted. So we felt like it was an elegant solution to both honor the rights that the state has, but also protect the community from just opening up the area for mining. As Becky stated, there is no legal reason that we couldn't allow it, but we did, and I've made a copy for you of the state DNR's application. We actually went through that, and we felt comfortable with this language, knowing that they still have to go through the state's DNR mining application process, which is 36 pages, which makes our 4-page UP application look pretty little. But it asks all of the questions that we would through a conditional use permit and more, and it also requires an annual reclamation update and bond. And so we felt that their application was as stringent, if not more stringent, than a conditional use permit. And this also includes a 30-day public notice to the community. So it still had all the information and the public comment period that would be extended through a conditional use permit, albeit it didn't have the public hearing. That being said, that's kind of how we got to where we are today and why we went the direction that we did. If this body or the assembly as a whole would want to see this as a conditional use permit, we would like to discuss that and make sure that it's not just adding a C to the use table. either we probably want to think about some language that we could help come up with before Tuesday that clearly tied it to these federal patent mines and not just to the districts.
So potentially we could say for these, we won't even use the phrase conditional use because gets us into the problem, but we'd say before mining occurs on these properties, we would want a public hearing, and the conditions could be put on it. We could list very, the hours of operation, noise,
So
quantity.
well, you could, but you need a mechanism to have that public hearing. So it has to either be through an application, and there would have to be. I wish Becky was here for this, for more of the legal ramifications, but in code, anything that triggers a conditional use has a process that goes with it, and so that needs to be thought out, because with public hearings, you also have community council notices and requirements. So I think we need to be careful by saying it would have to require a public hearing, and by who, and what would be the mechanism. So, and then their application. Sorry, I know you want to talk about their application. Actually speaks to those things like hour of operations, the trucks, and like the trucks associated with that. And this federal this application doesn't exempt them from local noise laws. So there's that as well.
Does it limit the quantity?
It does, yeah, and the quantity is further limited by the patent. So we know that the first one that will be coming forward is no more than 67,000. I'm saying that it might be give or take, a couple thousand cubic yards, but that one already is self-limiting, and I believe that they all are.
I think actually, Forrest, were you in the queue first?
Yeah, so I want to ask really quickly, could you repeat, you said that there was some language in the existing, was it a Girdwood plan or something you mentioned?
Yeah.
That was taken from where, what was that exactly?
Yep, it's in, it's the GIP district, which is Girdwood Institutions and Parks District, so it's 2105040.
So it exists in Title 21.
Oh yeah, sorry, 2109040. F, it's under other districts, and so within that zoning district, because if you look at the use table, natural resource extraction is exempt. It's also prohibited in the GIP. But in this district, they have the language that says federal patents to mineral estate and valid estate and subject mining claims, and then it says that within those, it's allowed. If you go back to the definitions within 2105 or 09, they have a definition for natural resource extraction, which actually says, for the sake of state and federal patents, that it's excluded because it's handled through this language.
So, just to sum that up again, you're saying that in the existing Title 21 Girdwood Institution Park District language, we already have this?
Yes, correct, right here.
If I can add too, there's 3 other districts that have this exact language.
Yeah, thank you. Yeah.
So not just the GIP.
Oh, what are the other ones?
The GR2A, the GI2, the GIP, and the GCR3.
Can you
translate those, please?
Yeah.
Girdwood residential.
Yeah.
I'd have to look at my book here, but
But they're various residential
they're all
districts.
they're all
Yes.
Girdwood.
All of this in all of chapter 9 is Girdwood. So everything we're referencing right now is specific to Girdwood, not anywhere else.
And so and I guess the distinction why this is only affecting Girdwood and not Chickasha Rivers, chapter 10, or the rest of the bowl, is because in both chapter 5 for all the uses within the Anchorage Bowl and in chapter 10 for Chickasha River, natural resource extraction is allowed conditional use in every single district. So Girdwood is the only chapter that limits within the use table where you can have natural resource extraction.
Okay.
Yeah, so I really like this state application. It's very comprehensive. Is there any way so that we could get the public hearing process, do some kind of conditional use permit where one of the things is that you have to have an approved state application?
We
Prior
could-
to making application, or as a condition to approval.
As a condition to approval.
So they're already required that. Yeah,
Okay.
they're required to have DNR approval.
No, I understand that, but what I'm trying to figure out, because I think one of the concerns is we want to be able to hear from the public.
Right.
Because public comment into the state is one thing, but having public testimony, I think, is a very different process. Is there any way to operate under the conditions like this is already complete.
Right.
And so then we're having a discussion that these things are already happening, but, you know, to get it at the municipal level, we want to evaluate, you know, neighborhood concerns and some other things.
So yeah, and that was actually one of the things we talked about when they came in, because this is redundant to a lot of things that we ask in our conditional use permit. And so they could effectively, if it was decided that there was going to be a conditional use permit requirement, we could accept this application, and then if anything else that we have in ours that isn't addressed, they could just, basically they could say see attached, and for everything that's addressed in the DNR application, and then anything that we have in additional from a local's perspective, they could just address that separately. Is that what you're kind of asking? So we're not asking them to do more
Before we
work.
go too much further down this road, Mr. Chairman, I want to interject that what we'd really like to do is explain the thinking behind what we've proposed, which is very specific to specific sites and specific purposes in a specific area. And it once we've had a chance to do that, and you've got additional concerns, questions, et cetera, like, can we introduce some kind of municipal public process related to this, whether it's called a CUP or not? We'd love to flesh that out, but this is a pending item in front of you, and we would really recommend against trying to duct tape and blue tarp this ordinance to achieve that. We're not saying we're not supportive of that, but if we're talking about some sort of new process for these federal patents, then it's actually a much more comprehensive discussion, because there's other places in the Girdwood Code that again exempts federal patents from any requirements related to resource extraction. So there's a bunch of different layers we're going to have to work through if we're going to create a new process. So if we could, what we'd like to do is, unless you have any other questions about what we proposed, hearing about your concerns or the items that you think should be addressed through whatever we're going to call this new process for these kinds of mineral extraction sites would be helpful, because then we can begin to formulate what the code changes would have to be.
Can I maybe interject on that? So they're working on the Girdwood area plan. I mean, is it not such a time-sensitive thing?
This is time-sensitive.
This is time-sensitive.
But this is.
This
In
is.
the broader view, though, that we could say, please add it to your list for your Girdwood area plan.
Definitely could be added for their broader view,
Discussion.
but
Sure.
we shouldn't hold off the
But
decision
this
of
is
this.
separate, but you're talking
Yeah.
about, this is right now, but this broader thing can wait.
Right.
Dean?
Thank you. I was beginning just now at the rest of 2109 for Goodwood District said the same language, like you said, Smithfield he was in, like 4 other districts, but there's a bunch of other districts where it doesn't have this language that you're adding to these 2 other districts. Is there a reason we don't add it to all of them? Is it just because we've identified where the parcels are within these districts?
Correct. We've identified where the existing patents are, and they don't exist throughout all of Girdwood. So, in that green,
This is the diagram of where they're located.
Yeah.
Sorry, it's not very clear. It's the red outlines. These are the existing patents that we're discussing. This is obviously Seward Highway. This map doesn't show it. We have another map that actually shows what the underlying zoning is of the areas, and I believe
actually
these-
that
No,
map
that
does.
The green is
The green
GOS.
Oh, I'm sorry, it does. Yeah. So this is GDR.
And the other one is
This
the
is the
GOS.
GOS.
Yeah.
So you can see we're talking about one in GDR and the remainder in the GOS. Now keep in mind, they have existing federal patents and active mineral extraction, material extraction sites west of Alaska Highway 2. And those are not affected by this because they're outside of the Girdwood area.
So they brought up that this might not be accurate, and I've actually sent this over
okay.
to Tina with our GIS department, and she's actually there looking at our underlying data to determine if we have any conflicts.
We got it from DNR, so
Yeah.
that would be good to know.
It's not correct. Yeah, it's not accurate. As
Hold
far
on,
as
let me get Dean, then we can get back to that. Dean?
Thanks. I have a separate question if you want to answer this matter first. But
Can we go to
yeah.
that regarding the accuracy of the map?
I mean, it would be interesting to see that, because I suppose the other information could be inaccurate too. But where we pulled information from the Unity's property information shows, for example, you can see, can I come up there? Is that fine?
Why don't you talk to that tape recorder with your name?
Yeah, sure. Oh, Brendan Maybe Jacobian, sorry, audience member. This is kind of the upper Timberline area. You can't really see, it's like the end of Timberline where you go to Virgin Creek Falls. But actually the Muni's property maps show that like GOS is all over here. And some of these are mixed GOS and GCR, which is I think actually commercial recreation. It was originally part of the golf course idea. I think it's probably got some that way. But yeah.
But Brandon, I think where the patents are shown, those underlying zonings are correct.
I think some of this one might be kind of in question just
Okay.
because I don't know how far GOS comes down in here. Our second question about that though was that like these patents, these numbers aren't, we're wondering where all the numbers match because like 233001 isn't on the 5, it's not one of the 5.
We got that from DNR.
Yeah, no, that was just sort of other thing that you
Right,
might want to
right.
find out about is that if 233001, where is that? You know what I mean?
Yeah. And we can get that information before Tuesday night.
Sure.
This is what GBOS used in their decision making, so.
I think that those two material sites are referring to the Kern slide sites.
Yeah.
Which is what Granite had come in originally to talk to us about.
Right.
So maybe that's what that site is.
So we'll get confirmation from DNR on what exactly all our numbers are. And then, as I said, GIS, because we're like almost at 95% accuracy, but every once in a while with our data, we are cleaning still some stuff up. So I have
Pulled
asked
it up,
them.
Michelle. It's actually identical to what we have on our zoning map. So on the Muni zoning map, this little green here is the creek drainage, I guess, and it's an extension of this GOS zone. This one that's now blank on the screen is, I think, is the one you were talking about, the GCR1, and then this is the GDR.
If you look at the, which is kind of why I brought it up, is sort of cross-checking it. If you look at the property appraisals and information section of the Muni website, you click on the individual parcels, it'll show.
Here's the zoning map. This is the one that I would rely on, not the property appraisal for tax purposes.
Oh, okay.
Okay.
And that's actually an ongoing thing.
That's what we're in the process of cleaning up.
Yeah.
We're working.
That's why we're upset, is because we looked at Muni property assessments
Gotcha.
when we purchased our property, and it tells us that GOS goes
Extended.
much further south than Patrick.
Which is why I was hoping to ask this with the attorney present, because I want to know about the Muni's liability to property owners, because people look at property appraisals, they know what the zoning is before they make purchases, before they decide where to live.
That's interesting. Thanks, Vic.
I want to turn back to the language in the proposed ordinance. So I noticed under both C in section 1 and C in section 2, I mean, it says mining activities shall comply with relevant federal and state regulations. So if we pass this as written, we're just going to defer to what the state and feds require,
Right.
and there will be no additional municipal process or overlay.
That's correct.
And that's what you guys are recommending, because the state process pretty much subsumes the requirements you generally have for conditional use, which is what you apply to the rest of the bowl.
Correct.
Okay. And this would,
And as noted before, that's how it has been handled in other districts.
and then why is this time sensitive?
One, because they do need to access their mining claim. They have a road project, DOT has a road project that they would like to use this. If they're not able to use this site, they will have to use, they have other gravel resources. The impact to the community is that there are going to be a lot more traffic on the road because they have to haul it in. I mean, that again should not influence your decision. It's just what the facts of the situation are.
So that leaves a little more question, if I may. So once they start their extraction, though, that doesn't exempt them from other processes within the municipality, like a whole road permit or other things, or
That's
there'll be
correct.
other
Yeah.
opportunities to kind of potentially mitigate the effects or control the effects of the operation through
That-
other municipal structures.
That's correct.
Okay.
Yeah.
Okay.
Thank you, that's very helpful.
Okay, I mean, this is a big deal to have gravel right next to your project. Right?
Yeah.
I mean, particularly in this area, this is
Yeah.
So is there a way, and maybe it's already, I didn't read the DNR thing here, but is it a possibility, or it's likely, that they will use all the gravel that they're allowed to take out of these in this project over the course of probably not more than 2 years? Maybe then we don't have to do anything. We say, look, you got 2 years, be done.
Right.
Use it.
Right.
And then we're over. And then I know some of the conditional use for gravel is restoration at some level.
Yes.
I mean, is that already in here? Or
Yeah,
just-
so they
in the
have.
application.
Yeah, it's in the application. They have to do an annual reclamation update, and it also has a bond associated with it. So essentially, they pay a large bond up front, and then as they start to reclaim certain portions, then that's prorated to kind of reflect what's left. But I mean, the municipality doesn't even require that with our reclamation.
Because that's fairly typical with gravel then, is
Yeah.
to do that. And it stinks for the neighbors for 2 years.
Exactly.
3 or 4.
Yeah.
Pete?
Thank you, Mr. Chairman. So have they extracted gravel from this area before, or they just know it's there and they decide they wanted to use it now?
They have not extracted yet to date. To our knowledge,
I
they
believe
were.
it was done in the 60s.
Oh, okay.
Yeah, it was done in the 60s, but they've not done it since then.
Okay.
Yes, is there something within the state mineral application that time limits the time of the operation?
It's what the applicant says. So the applicant's going to provide a certain date. Yeah.
So that it has to end,
Yes.
absent some additional process
Yes.
or approval?
So they have an annual. So I pulled up the multi-year permit. They also have an annual application, and then they have a multi-year, and that has certain how you have to come up with an annual report and all of that.
One more question, if I may. So we have 5 claims. Could they partition or access those claims, over the course of more years by not accessing the entire claim or doing a full extraction? Does that make sense? Can they kind of prorate their gravel usage so that they have it for other opportunities?
So if I understand your correction, so within the 5, could they take 5,000 out of one, 5,000 cubic yards out of the other, 5,000 cubic yards out of the third? I mean,
well, the one there in GDR, it looks like it's large. So
Yeah.
could they say, well, we have this project, it's going to use about a third of it now, use it for that, and then come back in 2 more years because they have the claim,
Yes.
resubmit a new application? Okay,
Yes.
and they could.
but once they pull out the amount of material that was allowed within that patent, they're done. So if there was 100,000 cubic yards that was conveyed, once they take out that, then they can no longer work that site anymore.
But this application makes it both date certain and amount certain for the amount that they say they're going to do for that
Correct.
authorization.
And this would be, I would assume, a logging mechanism so that they could say, okay, they've been approved for 30,000, and then there would be a logging that would happen.
Crystal?
Do you know how they ascertain exactly how much they can take out, what kind of yardage they can take out? Is that, and who decides that?
I don't know exactly in this instance, but in typical gravel operations, especially out in the Kootenai, it's typically by truckload. They know how many cubic yards to fit in a side dump or a belly dump, and so they know by how many truckloads. And they also have weigh stations, so they're actually getting weighed when the trucks get weighed when they come in and weighed out.
Well, my question really is, if you look at a site, how do they figure out exactly how much is available, how much material is in that particular location?
There are engineers that are able to look at a certain area, and you can calculate, okay, if I'm going to do a 10 by 10 swath at 20 feet deep, this is the amount of material I'm going to pull out.
Okay, so they know it's there. So somebody
Yeah.
figures out that they know this site has that much material
Gotcha. Yeah.
available. So they
Yes.
can do that way before they ever start deciding how much they're going to take out. They know what the facility or what the site is capable of producing.
Yeah, and they need to do that. So as Steve was saying, they do borings, and they need to calculate and have a good idea of where it's going, because it's like even a typical development site. Once you mobilize, you're creating a flat area where you're processing. So there is kind of a science to how these things get worked, because they need to make sure they have an area. So they don't want to start in one pocket and then have to find out, oh my gosh, we don't have the 30,000 cubic yards that we need for this project. We need to go over to another. That's going to cost them time and money, and they're not going to risk that. You don't want to touch material more than one time.
Michelle?
Yes.
Mr. Chair,
Go ahead, Chris.
I have a question. One of the biggest gravel operations I ever witnessed was a really smart one, and that was one that created the parking at Bird Creek, I think it is, and it also created that massive road extension. And my question is it possible for us to drive them toward transforming the gravel pit that they might create or whatever land they have into something functional?
Well, there is a dual purpose in this particular Kern site. The Alaska Railroad has an issue with avalanche and damage to their tracks and safety issues to the trains. So this is kind of a dual purpose site wherein the state gets the material for the road project, and the railroad shores up some of the safety concerns that they have about the avalanches in this particular area.
But as far as generally, just on on a broader perspective, it seems like we would, but I don't know if that would come from our comments on the road design portion or within.
Through the chair, Mr. Constant, I don't know that you can do that with all. You can't make that a requirement with material extraction sites simply because of the topography of the area. They may not all work, but as Dave mentioned, the largest is already part of a dual purpose site. The other sites, which are further southwest or southeast of Alaska Highway, I don't know that there would be much of a dual purpose out there.
I don't know.
But your point's well taken. In fact, I think not only the current slide, but one of the projects to the northeast of this site or northwest of this site is also a dual purpose one.
Could be, I'm not aware.
So, if I might, I like the idea of this framing of dual purpose, but I'm also looking at a public amenities, a way to bring the public along toward support, because it might actually create some long-term improvements. Anyhow, just thinking.
All right, thank you. Pete?
Thank you, Mr. Chairman. And so my question is, if they're mining, taking gravel out of this claim, and they find additional material that they didn't know was there, could they apply to BLM for a new claim?
I don't know about that, but the way, and I again wish Becky was here, I believe that the way this is written is it's existing patent, so I don't know if they would qualify for being permitted under how we're writing this code, because this was supposed to address existing claims, not new claims. So so technically, if it were an allowed use, they probably would be able to, but if we limit it to just the existing claims, I think we're limiting that they couldn't, because yes, they could through BLM, but they couldn't through a local process.
I see. Okay.
And we're not obligated to protect that because they haven't been that future gravel source, if that makes sense.
But through the chair, if I may, according in DNR's eyes and AK, DOT, and PF's eyes, these are all material sites. They're specifically designated as material sites. So I don't think that they're trying to find other stuff.
Okay, thanks.
Although DOT probably could use more money right now.
Anything else here?
I have one more question. Would you have any interest in being a part of the reclamation discussion to ensure that what's left behind isn't something that the municipality wouldn't want versus what the state is okay with?
I think, of course, we would. I don't know if it needs to be through a separate process or if it can be that we become part of the 30-day notice or public comment and that we can provide comment on that.
Right.
I think that would be perfectly acceptable.
Yeah, through the chair, if I may, that's actually part of the public comment that's solicited from DNR is comments on a reclamation plan.
And you guys feel comfortable that that's sufficient? Because when we put something in code that we're only going to follow state and federal regulations, that kind of pulls the rug out a bit.
DNR routes the application to the planning department for comment, and so they'll incorporate any comments that we have into their decision.
Okay.
So we have the opportunity to look at it.
We're left with what's left.
Right.
Okay, thanks. So I got Dean and then...
Put me on the queue, Mr. Chair.
Let's do Dean, Chris, Brennan.
Considering, I guess, the conditions process possible, and the bus, this ordinance, I have to get through, and it's only conditions for that brings to mind, I didn't see much comments on the commission review of this ordinance. And did they review it? And if they haven't, we should probably put it in a section.
We presented
it.
Through the chair, yeah, the Planning and Zoning Commission was notified via director's memo, like
It was about
2 weeks.
3 weeks.
It was the night before the.
Yeah,
It was just
2
last
weeks
2
ago.
weeks ago.
Yeah.
years ago.
Okay,
And
so,
we
but Dean's point is to overtly put something in here then that says they were notified and
Yes.
we are
No,
we
they-
skipping code in any way?
So the
Typical
original justification for the approach was that this was an oversight between old code, new code. I think we're a little less convinced that that's the case now, but yeah, but pending this discussion, if there's going to be more substantial work requested on behalf of this issue, obviously we probably scrap this ordinance, go back to the drawing boards, and it would go through a full Title 21 Planning and Zoning Commission review process for code amendments.
And so where is DOT with this though? I mean, their project is coming up. Like
So
now,
this
they're
is
building.
time sensitive. Let's
Yeah.
not forget that. This is time sensitive both for the contractor that DOT is paying and for DOT. So we would work swiftly, but if the body wishes to kill this ordinance in order to work on something more comprehensive, that's what we'll do.
Is this project this summer or is it next summer?
It's this summer.
It's this
So,
summer.
Yeah, it's
you're doing
current.
it.
so DNR has contacted me and said that they are ready to issue their permit next Tuesday. Well, I should say following next Tuesday, should the assembly approve this ordinance. So,
Do we have a completed application? This is some, I just
No, I just provided a copy of it, like what the general application is, but they have submitted a specific application for their
Can
site.
you send that to the assembly members then?
Yeah, I don't
Before
know.
Tuesday? Let me see, I had,
Do we have a copy?
Dean was done, then I had.
Chris on the phone.
Chris, I'm sorry, go ahead, Chris.
Thank you. I actually have to depart so I can get downtown for the Enterprise Utility Oversight Committee that starts in 30 minutes. And I had added an item at the end of the agenda, and so I don't know when to take that up, but I will call in from my phone instead of my office line here, and I don't know if I need to have Mandy help me do that so that I can finish this conversation.
Is it time sensitive? Can we maybe just sit down with you, me, Crystal, and maybe Chair Rivera?
Actually, I have just 2 items. It's really simple. I'd like us to invite Neil Freed to come talk about the state of the economy and the impacts on Anchorage. And I'd like to invite the CEO of Credit Union 1 to come talk about their banking program, but we can talk about it later.
Okay. No, I think that would be interesting. All right, thanks.
Yep.
Forrest.
Yeah, I just wanted to say, I don't know if we intend to do a recommendation on this committee or not. But, you know, this issue seems a little bit attenuated from my district, our district, Pete and I. But I can say there are literally thousands of our constituents that are driving along Seward Highway this summer, and they would very much appreciate to have shorter haul routes for the large trucks. So I think if you were to poll our constituents, I think they would certainly be in support of us passing this.
But also, the more money you save on a project, the more project you get. That's very significant. So, okay, so we got Brendan.
Yeah, I guess one thing I would quickly point out about that, though, is I think the constituents would also be interested in less traffic accidents, and this is a big speed-up, slow-down area, and this is also a scenic byway, and that's important to consider as well. But one thing I wanted to point out, and I actually appreciate, you know, the idea that Michelle was talking about earlier, which is that, you know, not putting something where this in the table where this could just blow out to any sort of application. That's appreciated for sure, being specific and sort of getting more. But I would like to hear about other ideas about, you know, other structures, other ways that this could be tweaked to make it even more, I don't know if restrictive or responsive to the public is more what I would point out, because first, for example, one thing I would point out is that we're currently in the formal appeals process for 233001, the current appeal. And I would actually encourage you to look at all of the documents which surround that issue. You know, DNR is actually not terribly responsive to public concerns, and that's something that GBOS noted in their resolution that they brought forward to the Assembly. And I've actually had a recent state ombudsman complaint against DNR regarding another material site. And it appears that at least for some material sites, DNR is actually technically not even required to respond to the public, let alone even basically they don't really have to care much what the public says. And our appeal for the Kern site, for example, they really didn't take into account anything. For example, blasting. A lot of these sites would require blasting probably, and the response was just they'll follow standard practices for blasting. That's it. So I think a lot of the sentiment in the room here about being responsive to public concerns and residential concerns and potential impacts to property values. DNR doesn't seem to really care much, and it doesn't seem like they're actually much required to care much. So that's a concern I have with having faith in their process, I guess is what I would say. So I would be interested in seeing some sort of other tweaking to incorporate more municipal responsiveness to municipal concerns.
So we have a webinar that we're hosting here at 10:30. So I hate to rush, but we are at almost that time. So, and I think that the question that you have is more deserving of just a flippant, well, there's this. And because I think we need to be thoughtful about how we look at creative ways, is if we have existing tools, so we have the conditional use permit process, it seems like that could be way redundant for what they already are required to do and maybe not as necessary. And absent of that, we may be creating a new process. So I would like to just ask the body if it's okay that we take a moment to kind of think about mapping out what it would look like if we did a conditional use permit, some type of an abbreviated conditional use permit that kind of gets to the heart of what you all have suggested about the reclamation and making sure the public comments are heard, but also being respectful that this does cut down costs and gets us more project. And if we can maybe have something to you by Monday that maybe outlines a couple things that we have time to also vet them through legal and just make sure that that we're not just throwing darts at this.
That would be helpful.
Okay.
See Crystal real quick.
Well, and I'll just probably let my comment go then, because I would be interested in looking at that, because obviously we want some restrictions on the actual operation. We don't want 24-hour gravel extraction going on next door to somebody's house. You don't want them working on maintenance of equipment even overnight, because a lot of times they'll do that. They're not using the equipment during the day, so they decide, let's go make sure our equipment's working well. And so anyway, a lot of noise goes on with those. So let's wait till we see those.
Say, is there something we might need to do with regard to one, but not all of them right now? Is that possible? I guess that's something to consider. One is time sensitive, but the rest aren't.
Well,
it's not really,
no,
because
they're
this is
tied
a
together.
zoning issue, so it's zone-wide, it's not
We're not-
site-specific.
But you have two different zoning types.
You could just approve it in the GOS, but I think that the concerns that we're
Are
hearing
in
from
the
the residents
GOS?
is the GOS.
Okay, great.
I thought it was the GDR. Isn't that where their houses are?
Isn't the
Well,
GDR the pink, or is it the GOS the green?
GOS is the green.
But
Right.
Which zoning are you concerned about?
Mostly GOS, but they're all close to the community. That's the problem.
Okay.
Oh, I thought the
I thought we were-
GDR was pretty big, 'cause it's residential,
Mostly, but
where
not
the houses are.
In this sense.
Might be able to
It's not
answer the
abstract.
question better.
Okay,
later.
so wrapping up where we are. So we still have some unknowns, but we've highlighted some big questions. You'll have something for us Monday. I would say send it to all assembly members, kind of phrase it that way.
Okay.
And then be prepared on Tuesday for questions on it.
Definitely.
And then we have the public hearing, or we have a public hearing, right? Did we open it? And
You already had public hearing.
Did we close it?
You did not close it, I don't think.
Okay.
Actually, I'll watch it again, maybe you did.
No, I think
It was,
continued.
yeah.
Continue.
Yeah, I don't think we did.
All right.
So are you going to recommend amendments for this?
Well, we're going to look at different possibilities. I think that will propose amendments that address what we've heard today from both you all and then also the
All right.
community members.
Anything else?
Move to adjourn.
Adjourn.